Hi, it's Mike DelSignore. I'm outside the Haverhill District Court. I want to talk about what happens if you're charged with a third offense OUI. What I recommend clients' third offense is to try to get some treatment preemptively. A lot of times a client with a third offense OUI is going to be on conditions of release, such as alcohol-free. With testing, you might have to have a sobriety. So the court is going to order you not to drink. I would likely recommend a counselor for you to see if there's any other issues. Because on a third offense, you look at mandatory jail time. So we want to see first if we could get that reduced to a second offense. And to do that, we'll have to write a letter to the head DA requesting a reduction in the charge. And that's going to be based on things you do and that we can show in mitigation, pointing out weaknesses of the case. It's also helpful if we went to trial and you were found guilty. It's helpful to have done something proactive in order to get the least possible sentence. But often a third offense OUI approaches, we got to get a not guilty on this. Maybe you can't get a reduction, or you don't want to deal with the license loss. The license loss on a third offense, if you refused, you're looking at a 5-year suspension for the refusal, another 8-year suspension. So that's a long time not to be on the road. If you get a not guilty, it's a presumption of reinstatement. You can get the refusal suspension potentially overturned. So on a third offense OUI, what we're looking to do is attack the opinion of the arresting officer. You were intoxicated. We want to see how strong, how weak that opinion is. Is this a case where I can just cross-examine the officer and you'd be found not guilty? Or do I need other evidence? Do I need to contact your friends? Do you have to testify? Do we want to get medical evidence to challenge the officer's opinion? So what I like to do, once the case starts, we kind of gather everything. We talk to everyone, and then prepare you to testify, and then further on in the process, we make a decision of how we're going to try the case. I'll tell you ahead of time, based on my review of things, so I'm not inclined to call you to testify, or you got to testify. And a lot of times when somebody has to testify, it's because I need to explain something. In other words, if you admitted to 5 or 6 drinks and you're telling me it's over a long period of time, we need somebody to explain and put that in evidence that it was over a long period of time. Because otherwise it's going to come in and it's going to sound like you had too much to drink. So when there's key evidence, strong evidence, that without being rebutted, we might not win the case, or are unlikely to win the case, that's when we need another witness. We need medical evidence, or we need you to testify. So I'll go over that. I've been doing this for years. It's what I love to do. I help people, third offense, second offense. I've gotten a lot of not guilties on essentially every type of offense level. So I'm here to help to go over the license consequences. If you charge with a third offense, keep in mind you have 15 days to challenge the refusal of the RMV in Boston. You have to go to Boston no matter where you are in the state. So my cell is 781-686-5924. Feel free to contact me anytime. Call, text. It's never too late to call. I'm here to help.